not giving notice, well, that's required. Well, and when you take that away from people, you don't follow the rulemaking process, and you have to invalidate the rule. We are the Armed Attorneys. Today we come with extremely exciting and important news as it relates to pistol braces. Now, this is huge, and there's a little bit to it, but before we begin, show your support for the Second Amendment by hitting that like button. And this important video is brought to you by our friends over at Sonoran Desert Institute. Thinking about becoming a gunsmith, or if you're on the fence, you got to check out sdi.edu/armed-attorneys.
And today's episode is also brought to you by American Hartford Gold. As part of the firearms community, one lesson's clear. Relying on the government for protection, whether it's your life or your wealth, isn't smart. With soaring inflation, major economies abandoning the dollar, bank failures, and talks of government control through a digital dollar, the current state of affairs is uncertain.
Having a plan to safeguard your life savings from failing corporations and currency conflicts is crucial. That's where American Hartford Gold comes in, a precious metals dealer we trust.
They can guide you in diversifying your wealth portfolio with physical gold and silver. They offer incredible products, customer service, have a 5-star rating with thousands of reviews, and an A+ from the Better Business Bureau. On top of that, they support the channel and have an incredible offer to share with our community.
When you contact American Hartford Gold, tell them the Armed Attorney sent you, and they'll give you up to $5,000 of free silver on your first order. To learn more, text attorney to 65532 or call 866-856-2380 or check out the link in the description. All right, so the final rule on stabilizing braces that we have been, the ATF just can't leave people alone.
No. And can I just say, it is about damn time that really, the courts were like, they were, we talked before about it being like the rolled up newspaper and the no.
Yeah.
They're sending the pound.
Yeah.
It's done.
So let's get right into it. Effectively, yes. The final rule on factoring criteria for stabilizing braces is no longer in effect. There's a nationwide preliminary injunction in place. So every person, you otherwise qualified to possess firearms, these stabilized pistols, brace pistols, are not considered short-barreled rifles for the time being. That's what we get from the court.
Yes, which is great because we had this patchwork. And if you've been watching us over the course of the last 6 months?
Yeah.
We've gotten this patchwork of injunctions granted. This group here, this,
state of Texas,
manufacturer there, this, yeah. So it's like, ooh, who's really covered? Who's not? Do I have to join a gun group I wasn't a part of? Does that even work? And so we had all of these things. It was like, come on, just stop them already. Just stop them.
Yeah. But
I didn't think it was going to happen. I'll be honest with you.
Yes.
I did not think a nationwide injunction was coming. And yet, and again, thank you. God blessed Texas.
Yes.
Thank you, Texas.
But it's not just I would love to say, hey, preliminary injunction nationwide, everybody roll credits. There's a little bit to it. So we do have to go through some things, and there's some stuff you have to be on the lookout for, because this is not the end of the story. And so we're going to walk you through what happened so that you understand, hey, here's what could happen next, and then kind of decision tree where we go from there. So it's important that we go through this stuff.
Yes. So, I would say first thing, big reminder,
yeah,
which is very interesting for just future issues here that will continue to crop up in other parts of the gun world. This is not a gun decision.
No,
it's not. This was not decided on Second Amendment grounds. Mock versus Garland was not decided on Second Amendment grounds. Why not?
Well, it's because it's a statutory interpretation mechanism that the courts are kind of imposed on the courts, that if there's some way that they can invalidate a statute other than using constitutional grounds, they are directed to take those methods. And in this case, we have the Administrative Procedures Act that's in Title V of the United States Code. It talks about the rulemaking process and the way that agencies go about rulemaking, and it even talks to courts and tells them what they should do should rulemaking process not be followed. And that's essentially what has happened here. There was a violation of the Administrative Procedures Act, the APA, and the courts are invalidating it on those grounds, not constitutional grounds.
Right. So we're not saying here that, the SBRs are covered by the Second Amendment, and so we're not doing a Bruin analysis, which I guess it's good and bad, because we're looking at APA. We're really talking about the ATF's bad behavior in rulemaking, which really needs to be reined in. But of course, we're not setting Second Amendment precedent. So 6-1, I guess, in terms of is it good or is it not good? So what we've got is essentially this grand violation which is that you have to, when you're making rules, you have to give people certain notices, the American public, so that they can comment, so that you can, there are rules about rulemaking, right? That's why we get the 30-day notice and comment period, et cetera, et cetera, et cetera. And there is one particular rule about providing notice in sort of, I guess, not having too much discrepancy between your proposed rule and your final rule.
Yeah, if you want to check that out, that's in Title 5 USC 553, and that's sections B through C, and that's the core of the APA in the process that they have to follow.
So go back in time, and I know that y'all have been following this too. Cue like the ethereal music to remember
The waves
past.
in the past,
Yes.
past.
We have this form 4999, right? Which everybody was very up in arms about, us included, because it was insane and it had all the criteria for this is how you determine if something is an SBR, if it's got a stabilized brace on it. And it was, I mean, we actually did a preemptive training on it, right? I mean, we sat down with a bunch of Second Amendment lawyers.
And if you go on YouTube, there's 1,000 videos on how to run your gun through the worksheet.
Right. So, I mean, everybody was ready for this. And all of the comments that people submitted to the proposed rule were like, your form 4999 is effed. Like, this is crazy. And so that was sort of the focus of the general public.
Yeah.
And the court doesn't like that, because then what happened?
Well, they completely abandoned the worksheet.
Gone.
They went with hey, is there a rearward attachment? Okay, if there is, we're going to look at these 5 different criteria, position of the trigger on the firearm, is there an optic that you could only use if you shoulder it? How is it marketed? How is it used in the community? So
are there pictures of people using it scary?
Yeah. So they did a complete bait and switch with what we were provided for in the proposed rule, and then what the final rule looked like. And so we look back at the Administrative Procedures Act, Title 5 USC, different section here. This is 706. And it tells the courts what to do should the agencies not follow the rulemaking process. And it directs reviewing courts to hold unlawful and set aside agency rules found to be without observance of the procedure required by law. That earlier section we talked about. So in order, not giving notice, well, that's required. Well, and when you take that away from people, you don't follow the rulemaking process, and you have to invalidate the rule.
Right.
And where we get our precedent from in Mock v. Garland is the logical outgrowth test.
Right. So, essentially, the final rule has to be a logical outgrowth of that proposed rule. And if it's so different that they're essentially unrelated, then you have violated the APA. That's like saying, okay, we're the ATF, we're going to make a rule on stabilizing braces, and then that's the proposed rule, and then the final rule is on bump stocks. Right. I mean, it's like they have to be related enough that the public really got a chance to comment and to participate in the process.
Yep.
And if they're not related, there's no logical outgrowth, and the courts are directed to hold the rule invalid.
Yeah, but there's a little bit to this, because we have 3 different levels of relief that the court looks at when, evaluating. Let's just talk about the final rule on pistol braces. So we got all those temporary restraining orders. Those are really temporary Band-Aids on the situation. The court saying, I don't even know what's going on here. We're going to press pause, see what's happening. So, that's a little victory, right? We enjoy that. We're kind of on the second step of 3 steps with a preliminary injunction. So the court has evaluated the case a little bit based on the parties' filings and briefings. They haven't fully litigated the case yet, but they've looked at enough to say, all right, you're likely, there's irreparable harm. You're likely to succeed on the merits, that it's, in the public's interest. It looks at all these different factors, and that is where we're at right now. We have this preliminary injunction, which is so much bigger than a temporary restraining order, but it's not the end of the story, because we have one final step.
Right. And you're going to see that there are going to be dueling experts on the stand. The court's going to have a significant hearing before issuing a permanent injunction. I won't even say we, because I don't know what Richard thinks. Do I think a permanent injunction will issue? Yes, I do. Because in addition to this being very clearly a win on the legal merits, which is part of issuing the preliminary injunction and then the permanent injunction, we also have the issue of irreparable harm. We have the issue of what's best for the public safety in the community, right? I'm not using the exact words for how you evaluate a preliminary injunction, but in layman's terms. And those all cut in favor of the plaintiffs as well.
Yeah. And so to answer, yes, I do agree. I do think that we are going to get a permanent injunction. But briefly, let's just talk about, if we don't get a permanent injunction, all this stuff goes away.
Right.
This nationwide injunction on the final rule for everybody. Let's say the court denies relief. Boom, the rug gets pulled out from underneath us. I don't think that's going to happen. I think we're going to get that permanent injunction. Do we think the government, I guess the next question, do we think they appeal it, and where would they be going?
Of course they appeal it.
Right.
They appeal it to the Fifth Circuit. The Fifth Circuit, I think, upholds, and then it's a battle at the Supreme Court.
Yeah.
And it is, I think that we have a Supreme Court who's likely to rein in administrative agencies. We have a Supreme Court who's generally Second Amendment friendly, but bear in mind, this is not a Second Amendment case. I know
Right.
that it feels like one because of the Second Amendment outcomes, but it is not a Second Amendment case. It is much more boring than that, really,
Right.
at the end of the day, because it's a regulatory state case.
Yeah, but we see, and so this would, the Fifth Circuit, they can decline and say, hey, look, district court, you got it correct. But we have other district courts who have not issued injunctions or, TROs or preliminary injunctions. And so I do think the Supreme Court battle is set up. So nobody's going to miss this stuff. You're
No.
going to hear about it.
And it's going to be years, by the way.
Yeah, it's
But
going to be
let's
years.
hope that the injunction remains, the permanent injunction is granted.
Yeah.
And we don't have to think about it again for those years because we all get the use of our braced pistols.
Yeah, and these APA cases are winding their way through at the same time some kind of internet regulations are in how the FCC is regulating that. So there's going to be a showdown in the Supreme Court. There's too many things going on with administrative agencies going haywire. So we're going to see this stuff. And the three last things I want to talk about in this case, the plaintiffs really quickly, how we get to irreparable harm, and then our timeline to the Supreme Court. So let's start with our plaintiffs. These were the perfect plaintiffs for this case.
Yes, they were. You can't get better than war veterans who were injured protecting our country, who need stabilizing braces in order to enjoy the use of their pistols. I mean, there is like chef's kiss. There is nothing more perfect to set this case up.
Yeah, and that's a big part of all litigation is finding the right plaintiff.
The right plaintiff.
And so that's so wonderful. The next thing is the irreparable harm. I think it's very interesting how the court gets it. I mean, that's an important factor when looking at the criteria whether or not to issue an injunction or not. And they make it clear because there's sovereign immunity and all of these costs associated with, engraving firearms or destroying firearms or reconfiguring firearms, and you can't recoup it from the government because of that sovereign immunity.
Right.
Per se, it's irreparable.
It's irreparable because there are compliance costs, many of them monetary, and a lot of times in determining whether or not there's irreparable harm, the court's like, we don't really care that much about monetary issues because you can sue and you can get that money back. So it's not irreparable. But in this case, it is because of sovereign immunity. So the court does, I think, a good, quick analysis on that to determine that, yes, there is irreparable harm because you're not going to get your money back from the government.
And the last thing, the timeline to the Supreme Court, we look at, we can look at other cases as a guide, but I would look at our bump stock case, Cargill v. Garland, just granted certiorari by the Supreme Court. It's going to the Supreme Court. That's our bump stock case. Now, that took 5 years to get there. And so, I think we can safely say these pistol brace cases are not going to make it into the next term of the Supreme Court in 2024.
No.
Maybe 2025? What do you think?
Maybe.
So, we had the final rule going on, January 2023. It wouldn't surprise me if we're into 2026 before something happens. But, in the meantime, hopefully we have these permanent injunctions in place and hopefully we have some relief. This is a huge win, and we hope you enjoyed this discussion. If you did, consider subscribing, hitting that like button, and help us fight the anti-2A algorithm by sharing this video.
And please always question and comment for us below. Until next time, we're the armed attorneys. I played in a lot of dirt as a kid. I didn't really do
You
computer
grew up
stuff.
in Russia.
So everyone says. Well, because I don't know anything that happened between 1997 and 2004.
Yeah, comrade.